And welcome everybody to the 27th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman, the czar of the TCPA, the czar of just about everything. I got to note a couple things. First, we're in a brand new environment, which is actually our lobby. This is our lobby. Usually we shoot in our little podcast studio area. Today, the ladies thought, hey, let's just mix it up a little bit. I think they just wanted to show off the pumpkins. Fine, whatever. Well, a couple other notes as well, though. We have not done one of these in a long time. And the reason is that we've been on the road. Where have we been, ladies? Let's just shout out a city where we've been in the last 2 months.
Dallas, Utah, DC, Chicago, Florida, Vegas.
Yeah, so we've been on a national speaking tour is the short answer. In the last 2 months, we've made I believe 12 appearances in 2 months and 16 over the last 3 months. So no law firm in America has been as busy as we have been coming actually onto the road to meet you folks where you live in your home environments and to bring the good word of the TCPA to a stage near you. Hopefully all of you have had an opportunity to catch up with us on the road because you've not had a chance to hear from us. But now we're back. This is the first week I'm not traveling since August, folks. And as we speak, it is the middle of November. So it's incredible to have all of you back. But with that said, let's throw it around. Who do we have? We'll start with you.
Hi guys, my name is Brittany Andres. I'm partner at Troutman & Mean, and I'm also known as the Baroness of TCPA World.
Fantastic to have you, Baroness. So good to have you, as always. And by the way, I think last time you weren't here, so it's good to have you back. And Blondie.
Blondie.
My name is Tori Guidry. I am the Dame of TCPA World and an attorney at Troutman & Mean.
The Dame, the lovely and wonderful and talented Dame. And right next to me, who do I got?
Well, you know you missed me. This is Queenie, Pooja Amin, partner at Troutman & Mean, and happy to be back.
I always miss you. I miss you all the time. But I actually didn't miss you much because you were on the road with me most of the time.
Yeah, that's true.
We have just been traveling. So much has transpired since last we got together. We're going to do a couple of, or maybe like 4 podcasts kind of in pretty close succession. At least that's the plan, to try to catch up because we really have missed so many things. The biggest thing that has happened, of course, since the last time we got together is there was this little tiny election, which I have actually characterized as a revolution because I believe the changes that our society are about to go through are going to be so enormous compared to a regular election. It's funny, when I was in 4th grade, I don't know why I remember this, but I remember my teacher, Mr. Leiby, telling all of us, these tender-hearted little kids that could never really understand this, hey, you are so fortunate to live in this country because whichever side wins, it's not that big of a change. If the Republicans win or the Democrats win, honestly, life is going to look more or less the same no matter what. But as we get now into 2024, this might be the first election ever where that's just not true. If the Democrats had won, society would have looked one way, and with Trump winning, it's going to look different. And what's fascinating, though, is because although I think there's going to be big, broad, sweeping changes throughout society, the TCPA world, I think, is going to look more or less the same as it did before. And that's really crazy. I think what the choices were for Americans as to the TCPA is a true conservative. And remember, right, the Republicans today are not conservatives. They are regressionists, right? Conservatives mean you keep where you are, right? That's conservative. Progressive wants to move one direction. Conservative wants to stay put. Regression wants to go back, right? So really the Republicans are not conservative. They are, as MAGA implies, make America great again. We want to go back to something. Conservative, though, is honestly what Brendan Carr, the new chairman, is. I would consider him to be a true conservative, meaning I don't expect our new chairman of the FCC, and I could be wrong. Obviously, I could be wrong. But I don't expect the chairman to, for instance, try to roll back or change any of the anti-robocall provisions that are currently in place at the FCC. I do not expect him to go out there and start cutting or slashing anti-robocall regulation or modifying any of the current rules, particularly the one-to-one consent rule framework that's currently there. So I think we're going to see a true conservative approach in the TCPA world, where essentially what we have today is probably what it's going to look like a year from now, let's say. Whereas in so many other areas of the law in society, I do not think that's going to be the same. I think you're going to see massive changes. But that's beyond the topics that we talk about here on the Deserve to Win podcast. A couple other things I wanted to just bring up real quick, and then we'll toss it around. We obviously have this big thing going on at Cal, but we're not going to talk about this. By the time you watch this, we as a team are going to have just gone to a completely different level, and you'll already know what I'm talking about, but we're still going to, at this time, not talk about it because we don't want to jinx it. But it's just amazing what we're doing. But the broader, I think, lead generation world, unrelated to what Troutman Amin is up to, is obviously about to undergo a massive change. By the time you hear this, we're going to be within about 2 months, and maybe even less than 2 months away from the rollout of the one-to-one rule, which, if you didn't see that massive podcast or webinar I did with Mike Fareed that had thousands of people have already watched this thing, you need to watch that, right? But, the punchline for our purposes is the one-to-one rule is going to go into effect on January 27th, okay? It's going to. So you have to be ready to go on that day, period, full stop, right? No asterisks, no footnotes, all right? You have to be ready to go. And that's the big final push here that we're seeing right now in society, in lead generation world. I love to see that, and we see as we move forward, the old way of doing things is crumbling behind us, right? I mean, you can almost just imagine it kind of reminds me of like a Atreyu or something like running through, right, as the nothing comes and destroys the world right behind him as he's racing. I mean, that's literally what's happening. Like, as the good players are going to the one-to-one regime, you just see lowermybills.com going out, Select Quote getting just absolutely hammered, Quote Wizard getting destroyed. Like, all the old institutions that were solid and just crumbling down. But the good news is, to quote Adam Young from Ringba, right, is that these massive changes are going to add longevity to the lead generation world. The regulators have looked down from on high. They have seen the lead generation world through our efforts, the efforts of Reach, the efforts of Troutman Amin. We have convinced the commission properly that there is value to lead generation, that this is a superpower of the economy, that it is really something that's very important to small businesses, and they have seen value to it. They've seen value to comparison shopping. They've elected to keep it alive, but it can't look the way it used to look. The days of dark patterns and abusing consumers are over. No more consent farms, period. We have to do this the right way, folks, right? And the Reach 2.0 standards have come out since the last time we got together. That might be actually the biggest news of all for TCPA world, is the Reach 2.0 standards, things that are very firm, very stable. You can really understand what they're saying. There's clear-cut standards, and if you comply with these, folks, you're going to be complying with the law, and you're going to be helping to create a better telecom world for everyone. It's a wonderful thing. You guys really should get on board. Join Reach. Help us to create this wonderful, telecom society, right, where people will answer their phones again, where people will feel safe, that they're not going to be exploited or mistreated when they fill out a form online, right? Help us to create a world where the regulators trust and work hand in hand with the data brokers and the lead generators, and don't view these guys as slimy, terrible, abusive people, which honestly a lot of them have been, right? Elevate yourselves, guys. Get yourselves out of that muck, out of that mire. Come to the light. Do things the right way. There's still plenty of money to be made. All right. Mm-hmm. That's my speech. That's me up here. I've missed you guys for a long time, so I just wanted to give you that. All right. That's all I've got today. Let's throw it around to see what the ladies have. Brittany, we'll start with you. What do we got there on us?
I have a case, Anderson versus Farmers Insurance, Inc. Farmers is being sued in a TCPA class action for allegedly making illegal calls without consent. This claim was brought under 227C of the TCPA related to the national D&C provisions, as opposed to 227B related to regulated technology. So the plaintiff must allege at least 2 illegal calls, not just one. While plaintiff alleges that he received at least 7 calls with the same exact female voice, the court found that the plaintiff actually sufficiently only alleged 1 call. So as to that 1 call, the plaintiff alleged he received a call from Farmers, and the caller stated he was from Farmers, and the court found that this allegation was sufficiently alleged because of the self-identification and the fact that the plaintiff received an email right after the call with a Farmer's address. As to the remaining calls, the court actually found the plaintiff failed to allege a sufficient link between the calls and Farmers, because each of the calls came from a different phone number, and the court viewed the plaintiff's allegation that all the calls had the same exact voice as merely speculative. So Because the plaintiff had to allege at least 2 illegal calls and there was only one, the court ultimately granted the defendant's motion to dismiss.
Yeah, a couple of interesting things about this case. First of all, farmers insurance getting picked on, the insurance vertical and the real estate vertical just getting launched on. By the way, that reminds me, I haven't even introduced our guest. We're going to have Alex Kruzyk, baby shark of the century, formerly with Greenwald, Davidson, Radbill, the #1 law firm for the plaintiff's shop in the country, and doing TCPA work. But now he's out on his own. And he's actually going to be talking about the real estate cases in particular. That's why the real estate vertical prompted me. Sorry, guys. I'm rusty. I haven't done this in months. But come back to the case. Yeah, so farmers insurance right in the crosshairs. We know Allstate has been picked on relentlessly. Farmers and State Farm have also had some problems here. But it is a fascinating case because the court said an allegation of an identical female voice was speculation, right? Like a human ear is not capable of discerning if something's identical or not. Like, and to be honest with you, I kind of like pausing to think about that. Like, I agree with what the court's saying. Like, how do you know it was identical, right? It's not like you're absorbing into your mind, like a tape recorder and then like playing it back in your mind. So it is actually, if you pause to think about it, speculative. But I'll be honest, if I was a judge, I would have been like, well, this is factual enough for me. So it really does just go to show, man, it's eye of the beholder. And oh, by the way, some judges, they don't want these TCPA cases, right? And they're going to find a way to get rid of it. So really fascinating ruling. Anything else on that?
No.
Okay. Well, Brittany, it's always good to be back in the saddle with you. I know we've been on the road quite a bit, young lady. We got a lot more ahead of us. But it's nice to be here today in the moment and present. So thank you so much. I appreciate it. Tortor, what do we got?
So another company that gets picked on lawsuit-wise a fair amount, OpenAI.
Oh, geez. But they deserve it. No, I'm just kidding. Keep going.
Well, they just had a huge win, not a final. So OpenAI wanted a motion to dismiss against Raw Story Media under the Digital Millennium Copyright Act. So as way of background, OpenAI is trained using hundreds of thousands of different documents to come up with their large language model in order to train it, for it to do what it does, which is essentially a prediction token. So Raw Media prompts it to say essentially what it knows about its articles. Now, Raw Media then alleges, because it knew a fair amount about its articles and it didn't say, oh, this came from Raw Media, here's the author, here's the title, that it violated the Digital Millennium Copyright Act. Well, OpenAI says no standing because there's no harm, and they're also not entitled to injunctive relief. Well, the court agreed with them, essentially, saying that unless they can show harm, exactly how this, what they call stealing of their property, came to, they have no standing under the Digital Millennium Copyright Act. Now, again, this isn't exactly final, and this isn't SIPA, this isn't several other statutes where they can be accountable for, scraping the web for this information, but it is a huge move to allow, OpenAI and other AI models out there to be able to scrape the internet for more information, just to train it without having the repercussions of, a class action against them.
Well, if they start training it on TCPA world, that would really be a problem, because then the AI would become so intelligent that it couldn't relate to regular people, and that would really be a problem. But in seriousness, this is a fascinating ruling to me, because to take the TCPA world example, let's say somebody developed a AI bot, and someone might do this, that reads all the TCPA, takes TCPA world, condenses it, turns it into an LLM response engine. So if someone asks a TCPA question, they're going to respond in the czar's voice based upon the aggregate of the thousands of articles I've now written, which, by the way, is not the hundreds of thousands that was trained on. So in all seriousness, it would probably be a pretty paltry, small sample, but good enough, because obviously you're talking about the czar here. So you could develop, I would think, an engine that could really respond to a lot of people's questions. How would I not be harmed by that? That feels like a pretty big intrusion upon what I've put out there. And yeah, I'm leaving it out there because I want the public to consume it and use it for its own purposes. But if some AI engine's developed and then some law firm starts using it to compete against me, as an example, so that would be an example of harm, perhaps. But just in the abstract, than just like training the AI on itself, it's not harm. Is that kind of the theory?
Well, I mean, it would have to be some kind of concrete harm. They'd have to show and prove exactly how they're harmed. How, like, oh, we lost X amount of subscribers because now they're using OpenAI to figure out this information. Just as in your example, you would have to say, oh, we lost X amount of clients because this law firm is now using their AI trained on TCPA world to be the best TCPA lawyers ever.
I would just go punch him in the nose. I'll be honest. I mean, let's just be real. I wouldn't even try to sue him. I'd just go punch him in the nose. Okay, well, thank you for that, Tori. It's an interesting ruling. I'll be honest, you're the AI queen around here. You were just on stage in D.C. You're like one of the most sought-after attorneys on AI in the country right now, which I don't know why I'm surprised by that. I shouldn't be. I mean, this is Troutman Amin, right? People come to us for emerging law because we are so much more on top of it than really any other law firm. When you put together your review at Elcock of like 800 different AI regulations, people lost their minds because they had no idea there was that much going on out there. And you were like the first person to ever try to aggregate this and like present it in a coherent fashion. It was pretty remarkable, Tor, to be honest with you. No wonder people were chanting for you when you took the stage. That was amazing. All right, Pooja, we'll close with you. What you got?
Well, the dame is AI, but
she might bloody be.
There's no telling. Some days I wonder. So I'm gonna kind of piggyback on Eric's fantastic opening remarks for our back to podcasting episode. You were talking about regression, being conservative, and then progression. And I know you folks have, our current viewers, the folks that have been watching us for months and months on already are used to, dare I say, conservative when it comes to one-to-one consent ruling, right? Troutman Amin has been working endless hours hard with its efforts with REACH, with the FCC, to educate you folks on the one-to-one consent rule. We are mid-November by now for you new folks that are watching, because I know we've picked up like a bunch of new followers with being on the road and et cetera. I encourage you to go back and listen to our previous webinars, our podcasts, Read TCPA World, to get apprised of the one-to-one consent rules. I feel like Troutman Amin has done its best to educate you folks in the industry on what is to be expected and what you need to do to be compliant. Now, with that being said, I'm going to give you some comfort there, right? Because we've helped you, get a little bit of cushion going. But unfortunately, but also fortunately, because you still have us, there is now a new ruling that you folks are going to have to really, really start picking up on and educating yourself. Troutman Amin is already ahead of it. We've been ahead of it. We've told you it's coming, and now it's come. April 11th, 2025. Folks, mark your calendars. The new revocation rules will be in effect come April. So, right now you should already be comfortable with your one-to-one consent landscape, or at least really close to getting there. Now, with the new revocation rules, what does that mean? What are these new rules? So, I'll break it down to you on a very high level. Eric, my colleague John Henson, and AC from DRIPS did a fantastic webinar on this just a few weeks ago while we were on the road, mind you. I encourage you to listen to it to get a little bit more details, but on a high level, 5 things you need to know. Number 1, now, any type of revocation across all channels must be honored within 10 days. 10 days, guys, that is your number. Previously, the FCC wanted to limit it to 24 hours. Because of REACH, they have now agreed, they have found that middle ground, just like they did with the one-to-one consent rules. They have now found a middle ground for you folks, and that is 10 days to honor revocation. Number 2, a consumer may now revoke their consent in any reasonable manner. So, currently, a lot of folks are used to stop, quit like words, don't call me anymore, maybe next time, just those generic stop like words that we're used to when we're processing revocation. Now you're really going to have to look at and digest a consumer's intent when you are processing revocation. And that may take a lot of agents or manual review of these. It might take platforms like, DRIPS has a solution out there for a text perspective. It may, take, you have a laundry list of more phrases instead of just words. It's going to take a lot on the back end, but I suspect it's going to take a lot of manual efforts to really understand what the consumer is reasonably trying to convey to you. Now, almost guaranteed that plaintiffs' attorneys are going to use number 2 and bring it into courts and test whether a judge or a jury is going to find whether it was reasonable or not. Yes, that was already the standard, the reasonable standards. The courts were already looking at it, but now, the FCC is ingrained in our head any reasonable means. Number 3, any stop messages to any marketing messages now means stop messages across all your channels, right? So if you're stopping to a marketing message, then you're going to have to stop all sorts of marketing across all your channels.
But not email.
But not email, texting. I'm talking about if
Voice,
you're governed by
texting.
the TCPA.
That's
Correct, right. I'm just talking about if you are regulated by the TCPA and you're receiving a stop notification to a marketing message. Number 4, any stop revocation. This is the big one, right? Especially for you folks on the servicing end, or have multiple in the mortgage industry, and you have multiple channels, multiple departments. This one's huge, right? A lot of folks in this industry, a lot of big brands rely on informational messaging to their consumers. Now, any stop revocation to an informational message or call means a stop across marketing and informational text messages. I have some pretty neat tricks that my colleague John Henson and I have came up with where we can assist businesses to kind of process this. It's going to be a long process, like really diving deep into understanding, who the head of each department, that's making the outbound call is, the head of your marketing, your servicing, your origination, your remarketing. You're going to have to really get deep into your organizations, especially if you're a really big brand. Lastly, now you're going to have that you are going to be allowed now clarification message, right? And this one's pretty neat, right? So once you get through all 4 steps, the last is you're going to be allowed to do a clarification text message to the consumer to really clarify whether they wanted to opt out of that specific message. This is, for those folks who are in charge of compliance at your organizations, I think this is a good opportunity to get really creative to help save certain types of messages and continue to allow certain types of informational marketing messages. But yeah, those are the new revocation rules. April 11th, 2025, mark your calendars. As you get past the one-to-one consent rules, really start focusing on this new rule.
Yeah, and you folks, you need to watch that webinar. I think it's got like 800 views. People are watching it. People are reaching out to us after watching it. We were obviously the first people, Troutman and Mean, to come to market with a breakdown of the new revocation rules because of course we were, right? Who else is going to do it? But what's funny? It's like we were literally on the road. You're right. We were in Dallas. Literally, we recorded that in a hotel room 2 hours before I got on stage and spoke to the 500 largest Allstate agents in the country, right? That's how much dedication we have. That was the only time we had. We squeezed it in to get this done for you all. Like, that's our level of commitment. We love all of you. We do all this stuff for free, obviously. We don't get paid for any of this. Nobody sponsors this. We don't make $1 off of this kind of work. We just do it out of love. And we make it free, and we don't put any barriers. You don't have to sign up. Just go watch it. It's on our YouTube channel. It's an incredible thing that we do. It really is. Speaking of incredible things that we do, how about an incredible interview with Alex Kruzyk? You guys might not know him yet because he's kind of new to the game, but trust me, he is a major player. He's bringing TCPA class actions left, right, and center. He comes from an amazing pedigree. This guy is a baby shark. He is a big problem. You really need to pay attention. And now, through the power of the Troutman and Mean LLP law firm, I bring you an exclusive interview with heavy hitter Alex Kruzyk, who's out on his own, just disrupting the TCPA waters. Alex, welcome to the show, man.
Eric, thanks for having me. Look forward to talking to you today.
So you are just kind of another shark in the tank, my friend. I want everyone to kind of understand your background, because you're not just a guy that walked in off the street, decided you wanted to do TCPA. You actually came out of one of the most powerful TCPA plaintiffs shops in the country and then decided to start your own thing. So just give everyone your background. Tell us your little backstory here.
Yeah, so out of law school, I went straight into, I don't want to necessarily misspeak on this, but I think the largest plaintiffs class action firm in the country, and certainly one of the most prestigious, Robbins, Geller, Rudman, and Dowd. And starting there, I worked on a lot of high profile, high stakes, very interesting class actions. My personal favorite, most interesting ones involved sports class actions involving CTE and painkiller abuse with the NHL and the NFL, and the VW diesel litigation back when they were doing the diesel emission cheating devices. So I started off working at the closest you could get to traditional big law background, except on the plaintiff side, and had a lot of experience on that side working on the largest cases that were in the news, and being a small part of the large cog in the machine that was working on those cases. So I learned a lot there on basically how to do things the big law way. And after that, moved to your favorite firm, Greenwald, Davidson, Radbill, and worked with Mike Greenwald.
Not my favorite firm.
Keep going.
Well, certainly someone that a team that you respect and work well with. But yeah, Mike Greenwald, Aaron Radville, James Davidson, Jesse Johnson, all great guys that taught me basically when I learned the big law stuff. I learned how to work hard and stay in my lane and do my small part of the larger puzzle. With them, I learned how to run a case from the start to the finish, and great group of guys. And it was, I eventually decided at some point in my life, it was either stay working for them or go out my own way and try my hand at it. And it was a tough decision because, again, such a great group of people to work with on a personal and professional level. So, you hype up how scary it can be if one of them shows up in one of the cases. And it's because, frankly, they just do everything the right way. And they taught me how to do everything the right way. And it's made it so that way when I started my own firm, it wasn't that hard of a transition because there wasn't a whole lot I didn't know how to do or that I couldn't figure out how to do on my own very quickly because they just taught me the right way to do everything. So that's my background.
Yeah, if you want to be a really great litigator, one of my, I guess the secrets to my long-standing and continuous success is we don't make mistakes, right? We execute. And when somebody else makes mistakes, you're very opportunistic, right? And you take advantage of that and you just hammer them for it. And I guess what's frustrating with dealing with Greenwald, I call him Number One. I guess I could call him the Iceman because he just never makes mistakes, right? It was like, not to say that I'm Maverick or anything, but if you think through like the first Top Gun, right? That was always the thing between Maverick and the Iceman is that maybe Maverick was more talented, kind of naturally more intuitive, but when it came to just like executing and never making a mistake, like that was Iceman. That's why his name was Iceman. Eventually, you're going to make an error, he's going to capitalize, and that's over. I kind of feel that way with Greenwald. When you were working with the guy, what was it like just to be like around those guys? Because Radville is a completely different character, right? At least from the outside. I don't know, maybe internally they're like, they're a lot more similar than they seem. But those guys seem night and day. Just give me the inside scoop. Like, what's it like? What was it actually like working for those guys?
As I mentioned before, it was actually scary for me to leave on my own, to go out my own way, not for the regular reasons you would expect, like, not having a steady paycheck, not having any security, anything like that. What was scary for me is I really genuinely liked on a personal level each and every one of them. They were fun people to hang around, reasonable people, and like, if I failed at starting a law firm, I know that I would be able to get hired somewhere else and work somewhere else. But my fear is I wouldn't be able to work with people that I actually genuinely liked being around and working with on a day-to-day basis. So they have different personalities. As you mentioned, Aaron's a little bit more fiery. Mike's a little bit more laid back. But on a non-working personal level, they're just easy to get along with people. Like we would often, if we want to talk shop or talk strategy, we'd often have a ping pong tournament in our office. And while we're playing, that's when we're talking about cases as well. So I can't proclaim to be anywhere near as good as they were, but I think the week I left was able to finally beat Mike left-handed, and he's a right-handed player. So, and I'm not bad. Like that's the level of intensity that they brought in ping pong. But yeah, just good people. And the reason they don't really make that many mistakes is it's just simply having workflows and processes and following them. So just basic disciplinary stuff like, look, if you're going to cite something, just check it. It's pain. It's a pain to do it every single time, but if you do it every time, you don't miss something. And if a schedule comes in, you schedule it immediately. You never miss a deadline. You just do it immediately. And if you always follow those rules, it's a lot easier to avoid mistakes. And yeah, that's really just good people to work with, and I think good people to work against. Like no one tries to make things difficult for no reason.
Well, you make it sound very easy, the practice of law. Just do your calendaring and read your cases. Like, what is there to it? Like, a monkey could do this. And no, we're not having ping pong tables. But it is interesting the way, you think of like Edelson and his obsession with volleyball and how competitive he is. And, Greenwald with his ping pong. There's something to these plaintiffs guys where like they like to pretend like they're kind of laid back or whatever, but the level of intensity they bring to everything. And it's the same thing with us, right? Like deserve to win is obviously our motto. Like I coach a little league team and you don't want to play for me because like I cannot handle losing under any circumstances in any context. It just drives me insane. But okay, so enough about them. Let's talk about you, man. So you're out on your own right now. Are you doing just TCPA class litigation, or are you supplementing? Are you doing other kinds of work? Like, what's your portfolio?
So my firm does, so it's myself, two partners, Brian Girabaldo and Logan Pardell. My partner Logan does almost exclusively FLSA labor and employment, or I guess basically misclassification of employee status and unpaid overtime claims. That's about 95% of what he does. So there's some aspect of overlap in which we can give high level advice and help each other pick up slack when needed. But those sorts of cases are dissimilar enough from class actions. It's almost closer to a mass tort in terms of how a lot of the procedural things work, that I thought I knew how it was going to work. And then the more I work on it, the more I help them, the more I realize it's completely different. There's just general principles that overlap. But other than that, my partner Brian and I do a lot of the consumer facing stuff instead of the employment. The main other thing we do other than the TCPA is something that it's got a bit of an ebb and flow to it, is Consumer Leasing Act automotive finance cases. So high level, it's claims involving lease non-disclosure or non-compliance, which often comes up, most recently at least, in the context of people buying their cars that were on a lease that maybe the price was locked into the pre-COVID, pre-used car market going crazy era. So you could get a car that maybe you leased that would cost $20,000 to buy, but it'd be $30,000 to buy that same used car on the open market. Well, dealers noticed and they started tacking on all sorts of improper fees. And, you know, whenever you go buy a car, you expect to pay a couple $1,000 of nonsense fees, however you want to call them. But a lease says what you're allowed to charge for a purchase. And most dealers were charging whatever they wanted to, because that's what they always do, except the lease doesn't allow that. So that's something that we work on as well, although that's almost always subject to individual arbitration. So we have a whole arbitration practice that goes on the side, and it's basically class actions and arbitrations.
All right, well, those are boring. Let's focus on the TCPA stuff. So, like, what's your portfolio look like right now? Like, just give me the inside scoop, man. Like, how many cases have you filed? How many cases do you have in the pipeline? Like, what's that look like? If you're Alex Kruzyk, like, what's your portfolio look like?
I try to have, I think it ebbs and flows, and there's always different hectic times, but I'd say at any given time, we probably have 25 to 30 cases going that are class or seeking to be a class case, whether that actually pans out or not. And specifically in the real estate context, a lot of the time when we file a case, we don't necessarily know if we're suing, you know, Wells Fargo, or sometimes we have a case where it's someone that literally watched a TikTok video on how to get rich quick from home and still lives in their parents' basement. We've had those as well. So I don't necessarily know what I'm going to get when I file a case, because a lot of these enterprises aren't, like, they're not publicly traded. It's not publicly disclosed financial information. So there's a constant churn of those sorts of cases that are being filed that don't really, you know, they don't turn into class actions for just simple economic reasons. But I'd say 30 cases is typically the stable state.
So 30 cases, pretty small volume overall, and that's consistent, I think, with Greenwald's model, right? He was always like, look, I'm going to have a fairly limited number of cases, I'm going to work these cases, and I'm going to win these cases, right? So unlike some other lawyers, I won't name them, on the plaintiff side that might have hundreds, literally hundreds of cases going, having no intention of working these all the way through, Greenwald's model was always, I'm going to have something in the low couple dozen, and I'm going to actually see them all the way through. So it sounds like you've adopted that model, which I guess doesn't surprise me, right? That's how you cut your teeth, so that's what you're going to do. All right. So if you don't mind my asking, and like, I'm just always very curious to talk to plaintiffs lawyers and what, you know, how they go about their business. Like, how do you go about bringing in cases? Like what is your referral network look like, or do you do advertising? Like, what's that look like?
Basically, 95% of that's going to be online advertising. We're a young enough group that's still trying to be a little tech savvy and do our search engine optimization and things like that. We're not mailing out, flyers or any no billboards, no bench signs on the benches. It's just search engine optimization and paid advertising that way. And then, given that we're 2 and a bit years into the firm operating, so we're now starting to get at least enough of a reputation and enough professional relationships where cases start getting referred. but that takes time. And that, the best way to get referrals is to have a referral succeed and incentivize someone to refer more cases. That's a slow organic growth, and the quick surge growth is online advertising. So it's almost exclusively that.
Interesting. Okay, so you're not advertising at like airports and hockey games and putting your logo on like Coliseum floors or anything. That's just what we do because we're idiots.
You're looking for a different kind of client than I am.
Yeah, but they're not going to be responding to any of these kinds of advertising either. But you know what? I just like to see this lion logo everywhere I go. It's really kind of what it comes down to. All right. So, is there any kind of on the TCPA? I know that's what you're focused on, the class litigation. Greenwald was famous for his wrong number cases. Still is. I mean, talk about just finding a niche and just writing it onto retirement. My goodness. Are you similar? Are you looking for wrong number cases? Are you looking for a vertical specific that you're focused on? Like, what's kind of your model?
So the main focus I would say that we've stumbled incidentally upon is the real estate market. And the main reason we've been going after the real estate market is we've been finding that there is really just systematic noncompliance with the TCPA. And a lot of the reason for that noncompliance is, I would say, a very cute interpretation of the law. It's a lot of these real estate firms, or sometimes they're investment companies that are seeking to buy people's property, are saying that, look, we can do whatever we want because it's not telemarketing. Telemarketing is defined as the offer to sell goods or services or an investment opportunity. So if you get spammed by someone, even though you're on the do not call registry and you've got no relationship with them, you get spam messages saying, we want to buy your house. We want to buy your house. Are you sure you don't want to let us buy your house? They say, okay, well, that's not telemarketing. It's offering to buy, not sell. But our perspective, and we've had success now with this in almost every circuit in the country at this point, including on summary judgment in one instance, is just taking a step back and looking at it, not necessarily from a hyper-technical linguistic point of view, what the statute says, but practically. How does this all work? What actually happens when you get these transactions? And what we've found is that a lot of these companies, what they're doing is they're saying, look, we'll buy your house, and they'll find a whole market. Let's say it's a neighborhood that they think is gentrifying, or a county. Sometimes they actually track people based on indicia of hardship or need that you have to sell. So they could do something like tracking who's just had a divorce filing. Well, they might need to sell their house immediately for cheap. Or who's had a fire next door, or a meth lab across the street, or pre-foreclosure. They have all of these various public records tracking it. Find these people, go ahead.
Or a twister hits their house, like in that movie, right? You didn't see that movie, did you, Alex? That movie, Twisters. The thing came, and then they were working for him, and the big black cars would go, and then there was, because in the first Twister, the corporate guys were the bad guys, but then they made them the good guys, but then they weren't really the good guys.
You and I are the ones who watched the movie.
Yeah, mind twisted. You see, because it's double entendre, because there's the Twister. Anyone?
Yes.
Anyone? Am I the only one that's...
Yes.
Okay.
In Hawaii, when they had, I forget where, it's not on the top of my head, but when they had the wildfires there, the tragic wildfires that devastated a whole community, I was reading news articles that people that were in shelters were starting to get spam messages from investors saying, we want to buy your beachfront property that you've had in your family for who knows how long, because it burned to the ground and they think that they can get an investment opportunity. So I have a lot of distaste for that for obvious reasons. I don't think the optics of that are good. And then legally,
but look, buying when blood on the street is a long American tradition, right? I mean, it's dark, and I don't disagree. Like, vultures are vultures, but you know what? Vultures get fed. So I'm not going to sit here and cast aspersions on people who have a different business model than we have. Certainly, I mean, from a certain perspective, you're no less a bird of prey, Alex. And just backing up real quick, I have to say, I completely disagree, by the way, with not your moral stand or philosophy. I mean, I may or may not agree with that, but I do disagree with your read of the law, because the reg says what the reg says, and it cannot be telephone solicitation unless you are, in fact, introducing a good or a service to be sold or rented. If you are not doing that, you are not making a telephone solicitation, and the practical impacts of what that interpretation entails are irrelevant. It's what the code says that ultimately matters. Am I wrong here?
And that's the argument that keeps coming up, and candidly, it's the argument that keeps losing, and here's why. If you hire a real estate agent for you and you want to sell your house, what do? They're marketing your house to third-party buyers. They're handling the paperwork. They're prepping the contracts. They're handling all the title. They're doing everything that you need to do to facilitate the transaction. And these will buy your house for cash offers. They're doing the same thing. They're marketing to third parties. They're handling all the paperwork. They're just doing it for their benefit rather than the consumers. And then the other part of that, it has to be an offer to sell goods or services. So they're offering goods and services. Well, they're offering services. Whether you don't have to agree, but a lot of the time there's a offer of service if they're buying your house, even if it's as simple as, we'll handle all the third-party stuff for you that a real estate agent otherwise would do. And then, okay, well, are they selling goods or services? I would say yes, because they're trying to take your house for less money than it's worth, providing all this free service, and then flipping it for something that it's actually worth. So, if you have a $200,000 house, they take it off your hands for $150,000, and they do all this stuff for free. That sounds like it's $50,000 to me.
Not buying it, Alex. Never going to buy it. Not even remotely buying it, dude. If I just negotiate a good deal because I have superior bargaining power, good on me. And if you're a consumer that wants out of your house quick and you sell for less, you know exactly what you're doing, right? That is not a service that you're paying for. That's a negotiation for the price of an asset that you're agreeing to. These are two different things, man. If I sell you my car and you're like, hey, I'll take care of title, I'm not selling you my car so that you can take care of title. I'm selling you my car. The fact that you're taking care of title, cool, appreciate it, but so what, man? That doesn't convert what's a buy-sell transaction into some sort of an ancillary service agreement. I'm sorry, man. You're way, and not to throw aspersions at your entire business model, but I literally could not disagree more. Now, we can have a discussion as to whether or not the law should be modified, the regulation should be expanded, whether or not these phone calls, as you said earlier, serve any purpose and are beneficial whatsoever to consumers. I'm willing to have that discussion, but I just flat disagree with you. Notwithstanding the fact that, by the way, you are also right that the courts keep agreeing with you and not with me, even though I don't get to argue these things, right? Obviously, if I get to go into federal court and open my mouth, I'm going to win. And that's why smart guys like you don't ever fight me, right? You guys see this all the time, right? The same exact arguments that I could smoke, and I say this with love, right, to all the other defense lawyers out there. Right, but you put me in front of a jury or in front of a judge, we have this discussion, we walk out of there, and there's this big W hanging on our wall, because that's the way it is, right? But you take this same cockamamie argument, and you go against some other defense lawyers, who I won't name, obviously, I'm not going to pick on anybody, and you just come out with win after win after win against these guys, and then at some point, it's very challenging for me, because now I'm trying to defend a case, and there's all these cases that go against, my position, not against me, because I never got the chance to open my mouth until there's 10 dead bodies over here, right? And you guys are much smarter. The plaintiffs' lawyers are much smarter than the defense attorneys, right? The defense lawyers, they never work together. They never are strategic. They even when I created TCPAworld.com to try to create, some strategy, some cooperation. I give away all my tricks, my tips for free. I give you, everything you want, defense lawyers. Just call me. Just include me in what you're doing so that maybe we can work together. No, never. Crickets, man. Crickets. So good for the plaintiffs' bar for being so smart.
I'm glad that's the case, because what you're saying is exactly correct. Good facts make good law. Bad facts make bad law. So there's fights that we might take a year or two later that we wouldn't take now because the law is not there. But if 10 more courts align with our view, well, then, you can push the envelope a little bit more and see just how broad that is. Because initially, when we were first looking at this issue, it was scary. And one or two bad decisions would have completely flipped that, and we would have had to look at some other industry or look at some other type of business model. But because we keep having those victories now, we can now say with some confidence, okay, well, every court that have looked at this issue that we've addressed now is saying, they're taking our side. Whether that's going to stay that way forever, probably not. We'll find the wrong court and the wrong judge, and then it becomes a nice little split in authority. But until that happens, we're trying to be very strategic with our fights. And we're going to disagree on those issues, and that's why we both have to work for somebody. But it's that's the fun of this whole TCPA world. It's not just, did they robocall yes or no. It's all about statutory interpretation and technology and privacy and all those issues that are surprisingly more interesting than people would initially think when they hear about the TCPA.
Yeah, you're going to get the wrong facts, the wrong judge, the wrong court, and the wrong defense lawyer, right? That's what I love about Edelson. When Jay was on our podcast, I mean, the guy was just so clear about that. He's like, I'm going to come up with a theory, and I want everyone to stand down. Like literally, I guess he goes to a conference and just tells all the plaintiffs' lawyers, no one bring a BIPA case. No one touch this statute for 2 years. Edelson's going to handle it for 2 years. We're going to make a bunch of good, sexy law for you, and then you can come all play, but I'm not going to have you screwed up until I get a chance to make the law. Could you imagine if I got to do that?
If only.
If I could just stand up on a stage and be like, hey, defense lawyers, all y'all just shut up. You're not allowed to make any arguments on this point for 2 years. Let my team handle it. We'll clear the way, and then you can go in and bulldoze. Could you imagine? How amazing would that be? How amazing would that be? The plaintiffs' lawyers can do it. We cannot. And so, good for you guys, though, because you're there. They are. They're so much more strategic. They're always thoughtful. All right, so I understand your current business model. As you're moving now into 2025, though, now I've talked to a ton of plaintiffs' lawyers off the record. No one wants to go on the record on just yet. I'll ask you. We'll see kind of what your position is. I didn't tee this up for you pre-game, so let's see what you say. The new 2025, the new one-to-one rule. Oh my goodness, man. I have talked to so many people who are just like, they cannot wait until that calendar page turns. They want me to shut up. They're telling me, hey, Troutman, if you just shut up, how much more money you would make on the back end because you're helping them to comply. Why not just let them not comply? Because that's not who I am, right? I'm not here to make money. I'm here to help people, for God's sake. Like that's why I do everything I do. But it's true, right? If it wasn't for Troutman Amin, seriously, if it wasn't for Troutman Amin, 90% of the people out there that know about the new one-to-one rule wouldn't know about it.
Correct.
Like it would be known by like a tiny sliver of small businesses out there. No one is trying to raise awareness at the level that we are, and the people that are now trying to raise awareness literally just jumped on the bandwagon that we created.
Correct.
So I mean, I wonder what the other universe looks like. I really do. All right, but that's enough time of me stalling, okay? Now to get to the question, Alex. Are you looking forward to the new one-to-one rule? Are you planning to exploit the ignorance of these poor small businesses that are buying third-party leads that don't comply with the law?
Well, I'm going to be very measured in my response to that. The answer to that,
yes.
the answer to that is ultimately, if we see a violation of the law, we're going to prosecute it, but that's almost impossible to predict going in. Most of the time, as I'm sure you're aware, if I see someone that a potential client that comes to me saying I'm getting these unsolicited messages or calls, I don't necessarily know, and I have to vet it with my client, but I don't necessarily know what the lead source is going to be. So I'm not seeking that out because I can't. I don't necessarily know, like, if some lead generator has this farms something out to 100 different businesses or one, I don't really know that until discovery starts. So it's not necessarily something I'm targeting. It's just something I'm aware of when the issue does arise later. And then I get to turn around and say, well, that doesn't comply. That's not effective. But I don't think targeting it is necessarily the right way to phrase it or the right way to characterize what we're doing. We're just ready to, adapt to the changing circumstances. And as I'm sure you're aware, with the regime change coming up, there's probably going to be whiplash back and forth on issues. And now that there's a lot less deference to the regulators and their opinions, we're probably entering a new era of just complete chaos with a lot of these sorts of issues. And you just have to adapt. That's basically the plaintiff bar's mantra, is just, we'll persevere. Whatever bad thing happens, whatever good thing happens, we adapt, we move on, we do what we got to do. And that's going to be my plan. I'm excited to see what sorts of cases emerge from that, and I expect bad things to emerge too. And if you don't adapt, you basically stagnate and die. And that's kind of the advantage of having a small firm like I have now, is that we can do that. And I'm sure you're the same way, going from large firms yourself, that you have the flexibility to move on the fly. And that's I think something that's going to be necessary in the coming years.
Yeah, we talk about that all the time, right? Being opportunistic, being nimble, right? They're big, I'm small, and that gives me every advantage I need, right? They're a lumbering dinosaur, man. I'll come in and slice you up before you even know what hit you. And you see it all the time. The speed that we can move at to market, both from a marketing standpoint, from deploying a new strategy standpoint, from like really just kind of hitting people with something they've never seen before. Man, the big law firms just suck at that. It's like they're just stuck in the old routine, the old model. There's no innovation. There's no penchant for innovation. All of that happens in little incubation shops like mine. But you mentioned, so you're going to pick on the little guy, I got you. But you mentioned the regime change, and you referred to it as a regime change, and I'm not sure if you're being cute or not. I'm calling November 5, I'm calling that a revolution. And I think it's just the permutations and the changes that are going to come about are so beyond what you would expect in a normal election. I don't think people have any clue what's about to hit them. And it's funny because when I first said that, I said that 2 days after the election, I referred to it as a revolution and not an election. And I got immediate pushback. I got a bunch of people saying, oh, come on, Troutman, you're fear-mongering. And now all of a sudden, with Matt Gaetz up for AG and some of these other picks, all of a sudden, people are like, okay, well, Troutman might be onto something. And of course I am. But what are you thinking, man? What do you see in the future with the new regime?
I'm not optimistic in a very simple term, and I'm going to be very measured in my response because the plaintiff's bar tends to skew a certain way politically, and that just is what it is. So this isn't necessarily going to be a good thing, but I also think, at least with specifically the TCPA, everything I've seen so far is that we're just not a high priority issue on the radar. There's going to be all those issues regarding like net neutrality and Section 230 liability and war, basically a war against social media back and forth, that I'm kind of glad to be out of the crosshairs, to be frank, and I'm hoping that this is just something that we fly under the radar for the next little while, and there's just bigger fish to fry.
Well, I mean, a couple counterpoints to that, though. What's interesting is, remember, Section 230 was recently used effectively by a big carrier, right? An RVM, ringless voicemail provider, to argue that their system was essentially just, a computer system that was basically sharing content of a third party, and they had no duty to moderate, including to apply the TCPA. So a Section 230 rollback would actually hurt certain TCPA defendants, which is interesting because most people don't see that coming. Second, Thune, right? John Thune is now the president of the Senate, and you may know this. He was the guy behind the Trace Act, right? So he is no friend to robocallers. So it's very interesting that the fourth most powerful person in the United States of America right now literally wrote an act designed to prevent robocalls and enhance the TCPA. So I don't know. I got to tell you, right, recognizing that the Republicans have always been anti-robocall, just like, wait for it, the Democrats, right? The only difference, I think, between the two is that Republicans are willing to consider the possibility that a business might actually have a reason to make an outbound call, whereas the Democrats just don't seem to even posit that as a possibility. But both are very, very strict when it comes to robocalls and wanting to stop robocalls, particularly those that are not consented. So as I look at the regime change, I mean, I see sweeping changes to our society. I mean, sweeping. But when it comes to the TCPA specifically, what's fascinating is that it might end up being business as usual to a large degree, which is really, really interesting. I mean, of all the things that are going to be disrupted in society, for instance, let's take Brandon Carr. We talked about this earlier. Brandon Carr is now going to be the chairman of the FCC. Now, the media is trying to make this out like it's, a Project 2025 author is now, going to be the chairman. Oh, he's a wild man. No, he's not. Carr he's essentially a moderate Republican. Like, the guy is not a zealot. He's not a bad man. I've met him. He's a normal dude. And maybe I'm like de-credentialing him to the Trump administration as I speak right now. But like, if Trump really wanted to throw a massive curveball at the TCPA world, Symington would be the chairman, right? That's a disruptor. So in this world, maybe only in this world, in telecom, in the TCPA, things might look more or less in January, February, March the way they did in October, November, December. So it's very fascinating, at least to my eye. Do you have a different take on that? Like, what are you seeing? What are you thinking?
I mean, I don't necessarily think they're quite as moderate as you do. I recall reading an article recently where he was angry at NBC and SNL for letting Kamala go on there and thinking that that was something that should potentially be prosecuted. I think that's something that maybe
He wanted to see someone's license get revoked. That's different than prosecution. And I'd like to see the FCC stepping in, by the way, because that cuts both ways too, right? You know, you got all these conservative networks using public airwaves to only broadcast one view all the time. That needs to get looked at too. So I don't disagree with Carr. Both sides need to recognize that if you are using public resources like the spectrum, you got to be fair and balanced. Like, and if you're not, then you're not you're not being a good steward of an American resource, which is our airwaves. But sorry, I didn't mean to cut you off, but go ahead.
I just don't share your optimism of it being applied evenly. And if things are there's only so many resources to prosecute so many different claims or arguments or issues, and I just don't necessarily think that the diehard right-wing networks that are only showing one perspective are going to necessarily be under the same scrutiny as the quote-unquote mainstream media. So I don't necessarily take a strong position on that. I just, my overall view with all of that sort of stuff, all of the larger political issues, is keep my head down and not be the next target. So,
none of that for me. None of that for me.
This is probably something that we just want to ride it out and let what the cards fall, the chips fall where they may, and then adapt as we have to.
All right, fair enough. All right, so as we wrap up, man, you've been a great guest. I really appreciate you being so candid and open. Anything else you want to talk about? Anything unique to the TCPA? Anything that you want to tell people out there? I know that you've been, I'll use the word targeting. You might not want to use that word. It's now a foul in football. Targeting the folks that are making these real estate calls. Any other kind of groups of people that you want to talk to? Say, hey, look, clean up your act, or any other closing thoughts here as we wrap up the interview?
So I know we have these statutory interpretation arguments about what constitutes telemarketing or not, but I take a very overly simplistic view on all of this, which is just simply get consent, there won't be a problem. And I'm not trying to look at these fringe issues of is there maybe consent here and there, is this one-to-one, the one-to-one consent issues. I'm not targeting that. I'm not looking at that necessarily where it's changing in real time. I just have a simple approach. There's a do not call registry that says don't telemarket to someone unless they give consent. Get consent. And if you don't, you're playing with fire at that point. And even if you think that you have a cute interpretation of the law or an angle where you think that that's okay, the logical conclusion of that sort of thinking is always, I can robocall or telemarket forever with no restrictions and no one can tell me to stop. And that doesn't sit right with me. And I guess I'm enough of a true believer that if I'm getting presented with arguments saying I can telemarket forever because this isn't telemarketing, you lose. I'm going to find a way to turn that around and say, no, just follow the same basic rules that both sides of us agree with, which is get consent, do things the right way, then there won't be a problem. Because I think that your firm and mine are two sides of the same coin. You provide the incentive of comply up front, don't get sued. So you're the carrot, I'm the stick. If you don't comply, then bad things will happen. So we probably have the same ultimate goal. We just approach it two very different ways, and I think they're both necessary.
Well, you mentioned the two most dangerous words, and it's not carrot and stick. It's true believer. And Alex, you are a true believer, and I know, it's interesting. Like you have this baby face, right? You look like a young, eager fella, but I know how you grew up. I know how you cut your teeth. I know you're one of the most dangerous adversaries out there, which is why I wanted to bring you in and have people kind of hear from you and hear your perspective. So, Alex, great interview. I really appreciate you joining us. Thanks for being here, man.
Thanks, Joe. Thank you very much for having me.
Wow. So I'm going to tell you something. I didn't like that.
Okay.
I didn't like that. I'll tell you why. I like bringing these guys on so that people can listen and get a sense of them and really kind of understand the adversary that they're facing and how sophisticated they are. Alex, from a certain perspective, kind of played everybody. And I respect his game. I respect what he's up to. He played aw shucks, right? Aw shucks, I'm just a little guy. I mean, I'm just getting started. I don't really know what I'm doing, right? How many times did he say, oh, I just hope I know how to do it the right way, right? He made it seem like he was not a threat. And those are the guys that are the biggest threat. And by the way, that was always Greenwald, right? If you talk to Greenwald, he always just plays it like, oh, geez, I don't know, we'll see what happens. I mean, well, maybe, maybe not. And those are the guys that have that obscene level of confidence because they know exactly what they're doing, but they're very disarming, and people don't see them coming. So all of you that are watching this, all right, I want you to understand, yeah, I know you saw a guy that was like, oh, gee, gollicky. Gollicky, is that a phrase? Oh, gee, gollicky. Everything's great, everything's fine. Don't worry about me. I'm just here trying to, put together some crumbs to make a loaf of bread. But no, these guys are dangerous. And that guy, he is a shark, trust me. Very fascinated, though, by the way he played that interview. Very, very interested in that. All right, let's throw it around. Let's see what everyone thought. Brittany, the Baroness, I'm going to start with you. What'd you think?
I thought it was a fine interview.
A fine interview.
I thought it was a fine interview. Some interviews are fun and some are, better than others. But
Thank you.
I thought it was a fine interview. Listening to how he started his own firm kind of reminded me of how we started the firm. He came from big law, similar to you. And so it was interesting to hear that backstory of him that I didn't know. But it was also interesting to hear about how he was bringing those real estate arguments, arguing that wasn't telemarketing. Like listening to you both have different positions on that argument and kind of discussing it was pretty interesting to me. And also, I feel like he almost conceded that he doesn't bring certain strong arguments against a better firm because he knows how that would end up. He just kind of waits and sees how the law will pan out and then brings those arguments when it's the right time.
Yeah, they're so much smarter than we are. I mean, strategically, right? They work together as a shark. I mean, I call them sharks. Do sharks work together, though? They're more like a pack animal. Like they're like a raptor, right? They're like raptors. They go out there, they circle around prey or an argument or a theory, and they work together to bring it down. They really do their best to avoid me. Remember when Facebook came out, right? And every single ATDS case we had immediately was dismissed. The plaintiff's bar never brought a single ATDS case against Eric Troutman. Not one, right? They take me out of the courtroom. They put me on the bench so I can't, do what I would do and go in there and bulldoze and make good law. Instead, they find their opportunity and they pick on the weak buffalo. I don't know why they're buffaloes now, but they pick on, the stray animals, the weaker defense shops, and they take them out. And it's smart. I mean, what can I say? It's just smart, right? It's good business on their side. It drives me crazy.
It's not good for us because when we want to bring a good argument and we feel like it's a winning argument, then we're stuck with all these cases that are not favorable to us.
No, I know. I know. This is why we created TCPA. I appreciate you telling me this like I don't know this. This is why we created TCPAworld.com, right, to try to help people. That's why we do this podcast, to try to help people, right? Like listen and learn and take what we give so that we can make some good case law together. But I appreciate those thoughts, Britt. You were dynamite today. It's crazy how long it's been since we did a podcast. I'm sorry I was a little rusty. I'm sorry my interview was only fine. It's fine. Thank you. Do you see what's happening? Do you see how I live? Okay, let's start over to you, Tori. How are you doing?
Yeah, it was an okay interview.
Thank you. All right.
No.
My worst interview ever. Got it. That's how we're going to build this, by the way.
But seriously, what I thought was interesting was how he made the true believer argument of, I'm helping all these people who are getting just blasted with calls after their house has been in a fire, after there was a meth lab across the street, everything like that, to kind of build up, the plaintiff's firm is almost like a good guy. And I don't know if that's part of a marketing scheme or what here, but I just thought it was an interesting approach, and maybe how he helped himself sleep at night. I don't know.
Well, there it is. I mean, obviously we're the good guys. They're the bad guys. Did you like the Twisters tie-in? I mean, come on. How could this be just a bad interview when I had that whole Twisters thing? We had that big, moment of realization when it was like a double entendre and.
Yeah, it was great.
Oh, shut up. All right. I'm failing here. All right. How about you, Pooja? Anything? How are you going to pick on me today?
In many ways, but I will save it for later. A few thoughts here. One, yes, Tori, I do think it's like a good storytelling mechanism that plaintiffs' lawyers do use. Obviously, they're on the consumer side, so when they're going up to the judge, those are the stories they're telling, right? And a lot of times that's what's helping them convince the judge to favor their side, not necessarily the law as should be applied. And that's unfortunate for a lot of us on the defense side, right? That's why we, when I started working with Eric, we don't represent scumbags, right, for that very reason, because we are representing companies and defendants who are good American businesses want to do it the compliant way, but you have these sharks and these baby sharks who are kind of weeding through the laws and making up interpretations and taking advantage of really, really bad law that's out there because of these bad big law firms that aren't doing a good job. So as they're trying to tell their story, we are too trying to tell our story. So just in response to your point, but a few thoughts here. One, Law Conferences of Champions next year is going to be for you defense counsel. It is no longer going to be for the businesses. We're going to teach folks. It's just a thought I love it. Right now.
I love it.
Secondly, it was funny, Eric, before you started talking, the first thing, as soon as that interview ended, I was like, he is baby Greenwald. He is a baby shark. And for those of you who don't know, Mike Greenwald actually, he fishes for sharks, right? That's a hobby that he does, and it's not by coincidence, right? He is aggressive out there on his boat. He is aggressive out there in courts. He is aggressive against defendants. And immediately I recognized that this, he had that baby face, but he reminded me so much of Greenwald, right? That calmness to him, that, it's fine. We're just, taking 25, 30 cases at a time. But that strategy of really taking those 25, 30 cases and making sure that they win, that has been Greenwald's strategy since I've first have litigated against Greenwald. In fact, if I was to rank the defense strategies, the plaintiff strategies that they use against the defense, Greenwald would be number one in my opinion.
Power rankings, like a power ranking?
Ranking,
just as an example, a power ranking? If only there was one of those. If only there was a plaintiff's power ranking somewhere in the world.
And I wonder, maybe on a website called tcpaworld.com, the same website that broke down the one-to-one consent rules before any law firm was talking about it? Yeah, probably that website.
Yeah, probably that one. Yeah.
So I had the same thoughts as you as far as him being like a little baby shark. And, he's going to do great, even though the girls found the interview to be boring.
Jeez.
I mean, it's we're going to look back on this interview, I promise you, in like 2-3 years, maybe even less, right? Maybe at the end of next year. And Alex is going to be right up there, right underneath Greenwald. And I mean, he, just like I was trained under Eric Troutman, he was trained under Greenwald. So that should tell you, everything you need to know. Last point, it was really interesting to see him downplay the one-to-one consent rules. It was very interesting, right? So if you saw, the strategies he's looking at is, well, did you have consent or did you not have consent? And that's a very interesting point because a lot of times, even in present day, right, you deal with these plaintiffs' attorneys and they ask you to give evidence of consent. And more recently, maybe in like the last 2 years when the lead gen industry started relying more on dark patterns to kind of trick the consumers, plaintiffs' attorneys are starting to poke holes, right, on all these new cases that we're seeing with the disclosures and the disclosure forms. I don't believe that, right? When he says, did you have consent, did you not have consent? It's not that simple in their world either, right? These folks are watching TCPA World. They are reading the SEC ruling. I mean, heck, they're the ones why the one-to-one consent ruling came out, right? They knew it was coming out before it was even coming out. And so they already know what they want the disclosure to look like because that's the disclosure they're going to use and take it in front of the judge and argue that this is the correct form. And I bet you it's going to have something to do, looks very similar like the Troutman Amin 15. And so I didn't buy that one bit. I think he downplayed it intentionally. I think it's because he knows partly that we give such great compliance advice and we are the front runners when it comes to telling businesses what you need to do now, that he downplayed it because he, in fact, does not want you to listen to the advice we're giving out in TCPA World.
Holy smokes, Pooja, you are fire today. Like, what is going on? You know what? I don't even have any thoughts. Pooja took all of my thoughts.
Close on that note. Well, sorry.
Do you have a mic?
Help. Send help.
It's been a long time since we podcast. I have a lot to say.
Yeah. In seriousness, though, this was fantastic. You ladies are incredible. It's always an honor to be hanging out with y'all. And I don't have any thoughts. You ladies took it all. The only thing I will say is, he mentioned how much he loved working with the team that he was with. I love every day coming and working with you folks. If I did not have the opportunity to work with such great people, there's no way. I mean, we put in 18, 20-hour days, man. Like, there's just no way that I would have the energy and the desire to push and push and push the way we have to push if it wasn't for working with a great team.
Agreed.
So thanks for being amazing, you guys. Thanks for being as committed as I am to the true beliefs of keeping Americans safe, stopping bad robocalls, but helping to inform people so they comply with the law and do the right thing, and most importantly, so they can all deserve to win. Love you all. We'll see you next time, and thanks for tuning in to the 27th edition of the Deserve to Win podcast. We'll see you next time. Bye, everyone.